We go ahead and finish up the offer to purchase and contract, and then talk about a few things, and then we'll look at that closing disclosure, CD number 2, the recommended homework assignment. And make sure you guys don't have any questions about that. And then right before we leave today, we'll talk about what tomorrow is going to look like, wrapping up. And I do want to have enough time for a review, because let's face it, we've talked about quite a bit in our very short time together. So before lunch tomorrow, I want the opportunity to kind of bring it all together for you guys to help you get ready for your exam tomorrow afternoon. And then rules and expectations of my exam. So you may have taken another exam with another instructor. So that's why it's important that you understand my rules and expectations for the exam. So that's kind of what the next day and a half will look like. Let's see. So, we'll talk about that in a second. So we're close to the end of this, which is why I want to go ahead and finish it while it's still fresh in our minds. This provision, paragraph 23, defines remedies. And between us, I wish they would have put it in the terms and definitions instead of in page 12, instead of in the throws, because I fear that it's going to get overlooked. But the forms committee didn't call me and ask me what I thought. So I'm glad that we have this opportunity to discuss it, because it's important that we see this. This was just added July of 2021. So, and understand this too, all this information was there, but July 2021, they pulled remedies out and gave it its own little separate category, I think to help pull us to it. But again, my fear is with it being somewhere on page 12, it just kind of gets buried in with everything else. So it's here. We start with talking about breach by buyer. In the event of breach of this contract by the buyer, seller shall be entitled to earnest money deposit. Remember we said, when's the buyer considered in breach? After due diligence, right? During due diligence is their right to terminate. For what reason? Any reason or no reason at all. So technically the buyer's not in breach until after due diligence. And should they breach, now the seller is going to be entitled to the earnest money deposit. The payment of the earnest money deposit and any due diligence fee to the seller without regard to their amounts, including zero. So again, if the parties agree to zero, their amounts are zero, and I still have a perfectly valid contract. So earnest money and due diligence to the seller, together shall serve as their liquidated damages. Remember, we talked about liquidated damages in chapter 9. Liquidated damages are money damages that we agree on when we enter into the contract. And aren't due diligence and earnest money negotiable points? Which is what makes them liquidated damages. We can't have a valid contract if we don't first agree to earnest money and due diligence, even if that amount is zero. So together serve as liquidated damages and is the seller's sole and exclusive remedy for such breach. Sole and exclusive remedy means what? Can the seller sue the buyer? No. The seller gets liquidated damages in the event of the buyer breach, and that's it. Seller's sole and exclusive remedy, but without limiting seller's rights under paragraph 4E, 4F for damage to the property. So again, we did talk about if the buyer's home inspector damages the property, the buyer's on the hook to pay for that, and that survives termination of the contract. Listing agents, it is oh so very important when you get an offer in, not so much in this market, but in another market, in the next market, when you get an offer in, it's so very important that your sellers understand the earnest money and the due diligence is all that they get. I mean, think about buyer's breach. We're outside, we're past due diligence, we're right before settlement. What if the buyer never shows up to closing? What if they breach right before close? Presumably the seller's already found somewhere else to live, right? They have a contract on another home, or they've signed a lease. So if the buyer breaches, the seller may have to breach their obligation, new contract or lease. That's why it's so important that the seller's comfortable, because they may need this earnest money or due diligence, these liquidated damages, to pay for breach of their lease or their contract. Does that make sense to everybody? Again, in this market, it's not a big deal. Sellers are getting $50,000 in due diligence. Well, I'm pretty sure I can break a lease for $50,000. Not a big deal. I promise you, this isn't always going to be the case. And when that pendulum swings back and we're in a buyer's market, we might start seeing due diligence for 50 bucks. Earnest money for 175, right? As the market changes, those are something that we will absolutely see change with that. So today, you don't have to worry about it. Sellers are getting more money for due diligence and earnest money than than what they ever have before. But just understand, this isn't always going to be the case. It is acknowledged by the parties that the amount of liquidated damages is compensatory and not punitive, such amount being a reasonable estimation of the actual loss that the seller would incur as a result of breach of this contract by the buyer. The payment to the seller of liquidated damages shall not constitute a penalty or forfeiture, but actual compensation for seller's anticipated loss. Both parties acknowledge in the difficulty of determining seller's actual damages for breach. One question I get a lot, and I think it's a valid question. Let's say that the seller has agreed to do repairs, they have completed the repairs, and then the buyer terminates. And the question is, shouldn't the seller get that money back? They did those repairs because the buyer asked them to. And the legal thinking behind that is no. First off, was the seller under any obligation to do those repairs to begin with? No. But second, the thinking behind this is, okay, so I'm sorry your buyer breached and they terminated. You got to put your home back on the market. But now you have a better product to put on the market, right? Because you fixed the electrical or the plumbing or whatever the repairs were. So you can kind of, listing agents maybe can use that to your advantage. You know, electrical recently fixed. You know what I'm saying? Kind of use that when you put it back on the market. The seller can't go after the buyer. Liquidated damages is it. Guys, I had buyers once, they called me 3 hours before settlement and said, we're not going to go today. And I'm a little slow sometimes. And I said, oh no, I hope everything's okay. When do you want me to reschedule? And they said, no, Julie, let me rephrase that. We're not buying this house. 3 hours before settlement. Of course, the listing agent was out of the country, so I couldn't get in touch with her. You know, it was a mess. But bottom line, I guess they got cold feet. I never did get a really good answer from them. They just decided, they woke up and said, this isn't the house and we are not buying it. And I said, you guys understand what all you're losing. You know, 3 hours before settlement, your due diligence, your earnest money is gone. The attorney charged them for preparing the documents because the attorney was ready for them, you know, so they, yep, nope, we're good. Don't want to buy that house. I said, okay. Sellers need to be prepared. What if? And listing agents, especially when those due diligence fees and earnest money deposits start coming back down, when you start seeing 50 bucks, and you will at some point, we just need to have a conversation with our sellers. It is a negotiable point. It's something we can counter, something we can work out. Questions or comments on that, on the breach by the buyer?
Julie, what is it? You said it's a negotiable point. What is it?
Due diligence and earnest money. Those amounts are completely negotiable.
Post breach?
No. While we're entering into the contract
Oh, I got you.
Yeah. So we agreed to him to enter in the contract. Yep. And listing agents letting the sellers know, if you accept this $50 due diligence and $50 earnest money, If the buyer breaches, all you get is $100, and ask your seller if are you okay with that? Okay. Then it addresses breach by the seller. In the event of material breach of this contract by the seller, if buyer elects to terminate as a result of such breach, buyer shall be entitled to return of both the earnest money and the due diligence fee, together with reasonable costs actually incurred by buyer in connection with buyer's due diligence. This provision shall not affect any other remedies available to buyer. So the seller breaches, they give back the due diligence, they release the earnest money, the buyer can still sue them. The buyer can sue them for consequential damages. We talked about those in Chapter 9, actually incurred by the buyer in connection with their due diligence. So has the home inspection been performed? Have they paid for the appraisal, pest inspection, survey, all of their inspections and investigations that have been completed so far? They can sue the seller. Remember, they can also sue the seller for specific performance. If they're awarded specific performance, then the judge will make the seller perform, i.e. sell. Consequences for seller breach are much harsher than consequences for buyer breach. Can we all agree with that? Seller just gets due diligence and earnest money. Buyer gets due diligence, earnest money, reimbursement of money spent, specific performance, right? I mean, they can go on and on and on. The big reason behind that, the seller's the one that initiated all this to begin with. The seller's the one that put a for sale sign in their front yard. The seller's the one that said, bring me an offer, I have a product to sell you. So because the seller is the one that initiated this, that's why their consequences for breach are much harsher than those for the buyer. And again, if your buyer looks at you and says, what should I do? Should I sue? Is it worth it? What are you going to tell them to do? They need to discuss it with an attorney. Absolutely. What should you do? Should you sue? I don't know. What should I do? You should talk to an attorney. That's what you should do. And then this remedy provision addresses attorney fees. If legal proceedings are brought by buyer or the seller against the other to collect the earnest money deposit, due diligence fee, due diligence costs, etc., the parties agree that a party shall be entitled to recover reasonable attorney fees to the extent allowed under this North Carolina general statute. The parties acknowledge and agree that the terms of this contract with respect of entitlement to earnest money due diligence each constitute an evidence of indebtedness pursuant to, again, this general statute. If the buyer, let's just pretend the seller's in breach, and the seller cuts a check for earnest money due diligence. Here you go. And the buyer still decides to sue the seller. They go after them for compensatory damages. They go after them for specific performance. If the buyer wins, not only is the seller going to lose that money, that compensatory money, but it looks like the seller's also got to pay the buyer's court costs and attorney fees. Once again, our contract's pretty clear about what happens if either party's in breach. So if they're not willing to release the earnest money, and this has to go to small claims courts, the party that's entitled to the earnest money, they're not the ones dragging their feet and not signing. So I take you to court for my earnest money. Even though the contract's clear, I still have to take you to court. Not only are you going to have to pay me earnest money, but you also get to reimburse me court costs. Oh, and pay your own too. So guys, let's face it. Let's be very honest here. Nobody likes to terminate. This is not a good day when you have to terminate a contract. It's not fun. Maybe sometimes give your parties a day to think it through. Sometimes, sleep on it. Things look different in the light of day. Try to have a conversation with them. Like, look, I'm so sorry we had to terminate yesterday. If you don't sign this release of earnest money, this is everything that could happen. Am I telling you this is what's going to happen? No, I'm telling you this is what could happen. Yeah, that's a good point. So the sellers wouldn't have to disclose it, would have to disclose if it wasn't fixed. I'm trying to make sense of that last sentence. Sellers wouldn't, we were talking about the repairs, if they did any repairs to the property. Sorry, I missed that chat. And the buyer terminates and the seller says, well, I wouldn't have fixed this if the buyer hadn't have asked me to do it. The seller doesn't have to disclose if it wasn't fixed, but the agent does. We always have a duty to disclose material facts. So, and remember, if the seller completes the residential property disclosure and they say, yes, this is broke, and then they fix it, we need to update the RPODs. If the seller says, no, this isn't broke, and then it breaks, we need to update the RPODs. We got to keep the RPODs updated throughout the transaction. And yes, your other question, due diligence fee and earnest money together serve as liquidated damages. Seller, sole, and exclusive remedies. Other questions on remedies? Okay. North Carolina Association of Realtors and the North Carolina Bar Association make no representation as to the legal validity or adequacy of any provision of this form in any specific transaction. If you do not understand this form or feel that it does not provide for your legal needs, you should consult with a North Carolina real estate attorney. When? Before you sign it. Once you sign it, you're in. Once you're under contract, you're in. Remember what we said. There's no excuse for ignorance of the law. Don't sign it and then say, I'll call my attorney. Call your attorney first and then sign it. This offer shall become a binding contract on the effective date, unless specifically provided otherwise. Buyer's failure to timely deliver any fee, deposit, or other payment provided for herein shall not prevent this offer from becoming a binding contract, provided that any such failure shall give seller certain rights to terminate as described, otherwise permitted by law. So now we have a place for everybody to sign. Buyer signs on the left, seller signs on the right. I only have a place for 2 buyers and 2 sellers. So if you have more than 2, we have an additional signatures addendum. And you can allow for, I think, 8 more. Don't hold me to that. I think 8 more signatures. So now you have 10. And if you need more than 10, you just do another additional signatures addendum. You keep doing your additional signatures addendum until you get all 20 of their heirs and their spouses, till you get all 40 signatures. We need everybody to sign. If your buyer or seller are an entity, then somebody on behalf of the entity is authorized to sign on their behalf. So if it's a firm buying or selling, we have that option. Wire fraud warning. Wire fraud's gotten really big, really fast in real estate. You think about the dollar signs attached to purchasing the home. So hackers saw this as an opportunity. I want to say some of the stats I heard, I think it was between late 2017, 2018, and most of 2019. So almost in 2 years, 17, 18, and 19, it was guesstimated that billions of dollars was hacked from the real estate closing table. Billions with a B. That much was hacked before it ever made it to the attorney or to the seller if they were having their funds wired. So we have a warning to both. There's a warning to buyers. There's a warning to sellers. We also have warnings to each in the agency agreement. So there's an there's a warning to sellers in the listing agreement, and there's a warning to buyers in the buyer's agency agreements. Bottom line, the best thing that we can do to protect our buyers and sellers is look them in the eyeball and tell them, I will never email you wire transfer instructions. And then don't do it. Because what they need to understand is if they get an email that looks like it's from you, with wire transfer instructions, I've been hacked. So by telling them that we'll never, ever, ever email them, hopefully it'll keep them on alert. They'll have a little flag goes up if they get an email that looks like it's from Julie. The best thing that they can do is go old school, pick up the phone and call the attorney's office and say, what are your wire transfer instructions? Don't call on a number from an email. Call on a number that you find on your, and go to Google and look up the number for that attorney's office. Don't rely on a phone number you got from an email. It's baffling how easily it is to intercept money from the settlement table. And guys, like back in 2019, I went to a wire fraud seminar in Raleigh. It was really interesting. The FBI was there, the title insurance guy was there, an attorney was there. I mean, it was really interesting. And the FBI stood up in front of all of us and said, hackers are always 2 steps ahead of us. The FBI said, once we figure out what hackers are doing, they've well moved on to the next. So let your clients know, and then obviously don't do it, but let your clients know that you'll never email them wire transfer instructions. If your buyers want to wire transfer their funds to settlement, they need to call the attorney's office and get that information. If your seller wants those proceeds, their closing proceeds, to be wire transferred to them, they need to pick up the phone and give that information. The FBI and, well, the whole wire fraud seminar, other things we can do to protect our emails, because throughout the transactions, we're going to have some client sensitive information in my Gmail account. I mean, my Gmail is about as secure as my closet door, right? So other things I can do to help protect. The FBI said, stop using password 1234. Stop it. It is not a good password. Have different passwords on your Gmail, on your free email accounts. You can have a 2-step verification. So when I log on to my Gmail, not only do I have to have a password, but I get a code texted to me that I have to provide the code as well. So if I don't know my password and I don't have my phone, then I can't access it. So they recommend that you set up 2-step verification. And the other thing they cautioned us about is accessing public Wi-Fi's. So if you want to go work at Panera Bread or Starbucks and you want to hook up to Starbucks's Wi-Fi, remember that's a public Wi-Fi and anybody could access it. When I'm working out and about, I access the mobile hotspot on my phone. And they showed us a little video. This young lady was working at Panera Bread. She was not wearing her I'm a hacker t-shirt, right? She was just sitting at Panera Bread working on her laptop, and she created a Wi-Fi called Panera Bread 1. And within minutes, people from all over the restaurant were jumping on her Wi-Fi. It was that easy. So don't just be, I mean, if you're accessing public Wi-Fi, you just like playing games or something, right? Don't have your client sensitive information. Comments on wire fraud, it's just baffling to me. I could spend all afternoon telling you guys different stories I've heard. I won't, because you won't be tested on that, but it's just baffling. So this is what's saying you should call the closing attorney's office at that number that is independently attained to ensure your contact is legitimate. You should not reply on a phone number and an email. And again, let your clients know. If you get this kind of email from me, let me know, because that means I've been hacked. So as we mentioned earlier, technically your contract's only 13 pages. It ends when the parties sign. This is the contractual agreement part. The last 2 pages are just information pages to help keep the transaction going, to help keep things flowing. So page 14 is the notice information. Insert at least one address and or electronic delivery address each party and agent approves for the receipt of or any notice contemplated by this contract. Insert NA for any which are not approved. So we talked last weekend about communicating. How do you communicate acceptance of offer? Well, that's why we have the notice page. How do you want the parties, how do you want communication to cross the line? Some agents, I'm going to let you guys get with your BICs on this because there's different schools of thought all over the place. Some agents don't complete the buyer notice and the seller notice. They don't put in the people's information. And then what they do instead is the agent's contact information. Some people will do all buyer, seller, and agents. I'm not here to tell you which one is right or wrong. I'm just telling you, contact your BIC, see if your BIC has a preference. But if you are putting in buyers and sellers notice, here's their contact information. And then confirmation of agency notice or address. This is the only place on the offer to purchase and contract that we belong. And we're not part of the contract itself, are we? We're just part of how we want to be communicated with. So again, buyers on the left, sellers on the right. You got the selling firm name, and then we have to choose. Is the selling firm acting as a buyer's agent, a seller sub-agent, or a dual agent? What's our role in this transaction? What's the firm's license number, mailing address? And then the individual selling agent, whether or not you're acting as a designated dual agent or not. So we have to disclose our status in writing by the time we're ready to present the offer. Thank you, Forms Committee, for just putting this on here for us. We have to do it anyway, so they just put it on here for us anyway. So now all we got to do is check the appropriate box of what role in the transaction you're playing. Selling agent's license number, phone number, fax, and email. And then we go through this little exercise again on the right for the selling, the listing firm, acting as seller's agent, dual agent, firm license number, mailing address, and then at the individual listing agent, and then whether or not if they're acting as a designated dual agent with their license number, phone number, fax, and email. If you don't want to be emailed, don't put your email address on this page. If you don't have a fax machine, don't create a fax number. Okay, this is the notice information. This is how we want to be communicated with for acceptance of contract, along with our roles. You do need a license number, at least your name and license number. Of course, I put everything on here. I don't care how you get me the contract. I just want you to get it to me. That's my thinking. And then the last page is our acknowledgement and receipts of money. So again, we're going to put the buyer, seller, and property address again here because usually this page gets printed off by itself. So it's not uncommon for this page to get detached from the rest of the contract. So just in case it does, we're going to have a place for seller, buyer, and property address. And pretty much anytime money changes hands, the receiving party needs to acknowledge receipt. So for example, we go under contract, yay. Buyer's agent meets the buyers to get their due diligence and their earnest money check. Call your buyer. We're under congratulations, under contract, congratulations. I need 2 checks. So the buyer's agent picks up the checks. The buyer's agent typically delivers the due diligence to the listing agent. When the listing agent receives it, they acknowledge receipt of the due diligence fee. What's the amount, the date, the firm, and who's receiving it? Can we all agree? Can we please all be in agreement here? Any monies, anything on its way and in your hand are 2 totally different things. Is everybody good with that? I'm going to drop it off after lunch versus actually having it in your hand. You guys don't need to sign receipt until you actually have it in your hand. There have been cases where the due diligence money goes missing. And the real estate commission is going to start with this form to track it down. And they go to this form and they see that the listing agent has signed it for receipt. And they called the listing agent and said, where is it? Oh, well, they just told me they were going to drop it off this afternoon. So I just signed it and left it at the front desk so they would have it to pick up. On its way and in your hand, or a lot can happen from point A to point B, right? What if the buyer's agent's in a car accident? What if they just forget? What if they get stuck in the McDonald's drive-thru? I mean, a lot can happen from point A to point B. So please don't sign for this money until it's in your hand. Once the listing agent gets it, then they're going to deliver it to the seller. And then the seller needs to sign acknowledging receipt of the due diligence fee. Again, the amount, seller or sellers who received it. And same thing with the earnest money. Escrow agent acknowledges receipt of initial earnest money deposit. Whenever you drop that off at the firm or the closing attorney's office, take this piece of paper with you and have them sign it. Date, firm, and who at the firm sign for it. And then acknowledgement of receipt of additional earnest money. And again, remember, additional earnest money is time is of the essence. So in addition to a date, we also need to know what time it was delivered to make sure that it was delivered on time, to make sure that it was in compliance with the time being of the essence. And that, ladies and gentlemen, is your 15-page offer to purchase and contract. 15 pages basically for the buyer to say, can I buy your house for X amount? And the seller to say, yep. 15 pages. Y'all want to hear something kind of sad? I told you guys I bought my little condo in 2006. How long ago was that? 15, 16 years, something like that. When I bought my condo in 2006, this thing was 8 pages. See how much we've grown in 15 years? We didn't have something called due diligence back then. We had alternatives for the buyers, and they could do alternative 1 and alternative 2. And for the life of me, I can't tell you what alt 1 looked like, but that's what everybody used. I can't remember. But alt 2 was basically what we know as due diligence today. And nobody did it because nobody understood it. So we all just did alt 1. And then they rocked our worlds when they said, we're going to do due diligence. Any questions or comments? Standard Form 2T. Was this good to go through it? Do we find this helpful? Kind of break down some of it. When they update a form, first off, the forms committees can typically only update forms in these forms in January and July. That doesn't mean every January and July we're going to have an update. But if we do have an update, it's going to happen January or July. I haven't seen an update in a January in a couple years. So the last few years it's just been July. Not unless some kind of law comes down. Every once in a while, there's a new law passed in which they have to do it in like August. But typically, they're going to do updates in January and July. When they do update the form, if you're paying attention to your surroundings, if you're actively practicing, you will know that they updated the form. Your BIC will probably want some kind of sales meeting to make sure we all go through the forms updates. The Board of Realtors might do one. NCAR may do a class. One thing that NCAR does when they update that I really like, they send us some information. So they send us a summary of changes. So it's like a bullet point. This is what we added. This is what we deleted. This is the word that we changed, right? They send us a summary of change. And then they'll also send us an offer to purchase and contract marked up. So they have highlights like this is new and crossed out, this was deleted. So they make it easy for us to see what the changes are. It's not like we have to sit there with an old one and a new one and find them ourselves. They provide us, they say, this is what we actually changed. I think it's important that occasionally you guys review and read these pre-printed forms, especially the offer to purchase and contract, listing agreement, and buyer's agency agreements, especially. Because what happens is we get busy, we get in a hurry, and we're writing offers for our buyers, and all we care about are the blanks. And in the big picture, there's fewer blanks than there are other stuff. So if you're only paying attention to the blanks, you're forgetting about the rest of this stuff. So please, if this is your first time going through the offer to purchase and contract, that's great. Please just don't let this be the last time that you go through the offer to purchase and contract. I think when they do a forms change, that's a great time to just sit down and read through it real quick and make sure you're up, you're current, and you know what the form says. Another reason I carry these things around in my trunk, sometimes open houses get lonely. I don't know if you've done an open house yet where you've gone 2 hours without seeing a soul. Maybe again, not, yeah, you have, you feel me? So what a great opportunity to sit there and just kind of read through our agency agreements and our offer to purchase and contract. Comments, questions, concerns? With in today's crazy market, and we're going to look at some other forms too. Have you guys heard of an escalation clause yet? Escalation clauses can get risky. So basically what an escalation clause, an offer's presented and the buyer's saying, I'll beat anything else you got on the table. I don't know what you have on the table, but I'll beat it. So they may go up in increments. They may just, I promise I'll beat any price you got. And back in April, the Real Estate Commission published this article, just kind of cautioning us on how to proceed if your buyers want to do an escalation clause. Again, you guys, times are tough for buyers right now. And they're desperate times call for desperate measures. And there's some concerns with an escalation clause. First off, you're agreeing you're to contractually be obligated to something that you have no idea, right? You don't know what the highest price is that's on the table. So yeah, I'll beat that. It's fine. You're agreeing to that. But the other concern is from the other side. If you're the listing agent and I'm the buyer's agent and you call me and say the highest offer I have is X amount, I have no way to verify that for my buyer. Because remember, I can't disclose the terms of an offer without the offeror's permission. So if you're telling me the highest offer I have is X amount, your guys have to beat that. You can't verify that. We can't validate it. Does that make sense? Now, once we go under contract, it's no longer an offer. So now I might be able to say, all right, show me your cards now. But by then it's too late. We're already under contract. So there's a lot to consider. I'm not going to say this is good or bad. I mean, the Real Estate Commission said pitfalls. So you kind of take that for what it's worth. But I'm going to actually put this, I'm going to stop sharing for 1 second. And I'm going to throw this in your chat if you guys want to look at it. I know a couple of you said you've seen it. Was this something that was, were you the buyer's agent? Were you the listing agent? One was presented, if you're willing to share, of course.
Can you repeat the question? I'm sorry.
A couple of you, when I said if you'd heard of an escalation clause, a couple of you said, yeah, I heard it. So I was just wondering if you guys have seen it in practice yet.
I have not.
No, not yet. Penelope, you're something's off with you sound like a little cartoon to all of us. That's great. Do it again. No, but something's off on your
My chat is disabled.
Are you on helium or something? Yeah.
My
Do what, Donna?
My chat's disabled for some reason. So
Your chat is again. Did I do that again? Oh, hang on. I'm still doing this. Hang on.
Just before it came on air with you, Eric, we walked the streets here in Lviv. We saw after air raid sirens sounded for the 4th time. People
There you go.
cover underground.
Okay, are you guys working again? Okay. I don't know why I keep hitting that button. And did you guys get the PDF I just put in there for you? Do you see that? Yeah. Again, grab it, check it out if you want. Sorry, Penelope, we can't. But thank you for the mid-afternoon. No, thank you. That was cute. All right, so that's that. Oh, let's see. Let's go back. Of course, now it's close enough to break time. I don't want to start the closing disclosure now and not being able to finish it. So as soon as we come back from break, we'll do that. But before we go to break, I just want to have a couple conversations, a couple other forms, and I know we still got to look at our addenda. I mentioned earlier, we also have an offer to purchase and contract for vacant lot and land. So if you're selling or purchasing lot and land, there's not a structure on this property. It's just dirt. So we have a separate offer to purchase and contract for that. And I'm not going to go through this. I'll let you guys do that when that opportunity comes up. We also have an offer to purchase and contract for new construction. And we're going to compare this one to the new construction addendum in just a minute. The difference in whether or not you use the offer to purchase and contract new construction or offer to purchase and contract standard form 2T that we just looked at with the new construction addendum, the difference is how far along in construction you are. If construction's almost complete, you'll use 2T with the new construction addendum. If construction has just started or you're standing amongst studs, you'll use offer to purchase and contract new construction. And I think our addendum helps us make sure we're using the right form. I was talking to a fellow agent earlier this week, and she got a call from an agent. They presented an offer for a new construction using standard form 2T. No new contract, no addendum, no offer to purchase and contract new construction, just standard form 2T. And the agent called her back and said, you can't use this form. Of course, the agent got all upset. I don't know why. That's the form they told me to use. Da 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 da. Remember that one very important sentence in 2T? This property is being sold in its current condition. And if you're still standing amongst studs and you present an offer with verbiage that says this property is being sold in its current condition, if the builder accepts that, he's done. Because what does the contract say? This property is being sold in its current condition. So it's so, and she argued with her. There's no new construction ta-da. So it's so very important that we make sure we're using the right forms to protect our people. Guys, when in doubt, find out. You have your BICs, you have, they call them seasoned agents. I don't like that. Let's call them agents with experience in your office. I promise you guys, I've worked in several real estate firms over my years, and I've never not been able to walk out into the middle of the room and say, I need help, and not have agents coming from all over the place to help. If you ask, somebody will be willing to help. Here's a fun fact for you. If you're a member of NCAR, North Carolina Association of Realtors, or when you join the Association of Realtors, NCAR has a legal hotline available to us, which means you can call an attorney and ask them questions. You can email an attorney and ask them questions. That's through your NCAR membership. We all want to know all the time, what do these dues pay for? Hello, free legal access. They and I've emailed them a couple times and they're back to me like that day. So it's not like you have to wait a long period of time. You have your real estate manual. This thing is a great resource. You have license law and commission rule in your, in the real estate commission's website. So please don't think, oh, I don't know, so I'm just going to do it this way. When in doubt, find out. You guys remember you are legally binding buyers and sellers together. So make sure you do it properly. I about blew my mind when that agent told me that. Why should I have to do another? One sentence. This property is being sold in its current condition. Look at a couple of our forms. Again, we'll take a break in just a second, come back and do closing disclosure, kind of break this up. Your test, you're going to have a couple questions on addenda and amendments, but they're not going to be like they're going to give you a scenario. And based on this scenario, you're going to use a backup contract addendum, FHA, short sale, or additional provisions addendum. So as long as you have a basic understanding of the addenda that we're looking at, you'll be good for your test. The backup contract addenda is used when an offer is being presented on a property that's already under contract. So you're under contract. That contract is referred to as the primary contract with the primary buyer. What the backup is hoping for is to get in a secondary position. And to be in a secondary position, if the primary terminates for any reason, the backup moves up and now they're the primary. So how these things work, we negotiate the terms like we always do. We're going to come to an agreement on purchase price and due diligence and earnest money and closing date. We're going to come to all of those agreements. And in addition to standard form 2T, we're going to have the backup contract addendum. So it says buyer and seller acknowledge that sellers previously entered into a contract with, insert the name of the primary buyer. Primary contract is pending, and this backup is accepted in a secondary or a backup position under the following terms. It's condition as backup that the primary is terminated. Buyer and seller shall be obligated to perform under this backup contract. So if the primary is terminated, the seller has to provide written notice that the primary is terminated, that the backup is now in the primary position. We're going to have due diligence and earnest money. The backup buyer does not owe due diligence until they become the primary. So if the backup never becomes the primary, then they never have to pay due diligence. We're also going to negotiate earnest money. They will deposit their earnest money. Remember, that's just hanging out in somebody's trust account, escrow account. If the backup never becomes a primary, they'll get their earnest money back. If the backup chooses to terminate while they're still in a backup position, they will get their earnest money back. The only time that the backup's going to lose their earnest money is if they become the primary and we go outside of due diligence, right? So all those rules stay the same. That doesn't change. This addresses all that. You know, I mentioned the dates earlier and that wasn't quite accurate. We can't put an actual date in for due diligence and settlement because I don't know if and when the primary is going to terminate. So instead of putting a date in, we're going to put a number of days. So once you've been notified that you're primary, you have, for example, 20 days of due diligence, 30 days till settlement. Does that make sense? Like I can't put a date in there, but I can put a number of days. We're also instructed in this note on the contract, instead of putting dates in, just put the verbiage, see attached backup contract addendum. So those dates in the contract will refer us to this section. Buyer's right to terminate. They can terminate this backup contract without liability by giving written notice of termination to the seller at any time prior to receipt of being noticed of the primary and Any earnest money deposit shall be refunded to the buyer. So if they never become the primary, or if they choose to terminate, they'll get their earnest money back. They're not out anything until they're the primary, if they get to be the primary. Buyer signs on the left, seller signs on the right. And then the last page of this, the seller has to provide written notice to the buyer that they're moved from the backup to the primary position. So that's what page 3 is. They give us that written notice. We don't have to try to create anything. So the seller is notifying the buyer that their primary terminated, and now the backup is moved to the primary position. This form only allows for one backup buyer. You can't have a backup to the backup and a backup to the backup to the backup, right? You can't start lining them out, lining up the driveway. One backup buyer. Questions?
I sent one on the chat, but so they
That's
put
fine.
down, that's okay. So they put down earnest money
Yep.
before they
While they're
become
in the primary. I'm sorry, while they're in the backup.
like a secondary, like they're being the secondary, but
They're
they
in
don't
the
put down
backup.
due diligence.
Correct. Correct.
Cool.
Remember, earnest money is just showing good faith.
Okay.
So if I'm telling you I'm going to give you 5,000 earnest money, then even as the backup, I need to be able to produce that, right?
Okay.
That's all they're doing is showing good faith. If I never become the primary, I get it back. If I terminate, I get it back. If I become the primary and I terminate within my due diligence, I get it back. All those rules stay the same. And yes, Donna, that's correct. They're not going to pay due diligence until and if they become the primary. So the buyer's not out anything until if they become the primary. Other questions on this? Anybody use this one yet? Seen this one? Have you? Good. This is one of these forms that's always been around, but in this crazy market, new life has been breathed into it. Because you think about it, you get a listing with 40 offers, that means 39 are rejected, right? So you may have one of those 39 that that want to come in as a backup position. Here's that new construction addendum I was talking about. We'll kind of do side by side. Again, I have a new construction addendum. This attaches to Form 2T, and it tells us right here. This form is designed for use when seller is a licensed contractor or has engaged a licensed contractor who has completed construction of a spec, who has completed construction of a spec on a property owned or to be owned by the seller, who will convey improved property to buyer and should be attached as an addendum to standard Form 2T. If construction of the dwelling is not complete, or if extensive additional improvements are need to be made, or the appraisal is dependent on the value, then we are instructed to use the offer to purchase and contract new construction 800T. So that's the difference in using new construction with 2T or the new construction offer to purchase and contract. It depends on how far along in construction you are.
Julie, I'm sorry. Can you kind of repeat that again? I just need to make sure I have it right in my mind.
So the new construction addendum, we attach to 2T. If it's done or almost done. If construction is not complete, extensive improvements need to be made, appraisals dependent on the value, then we're instructed to use 800T, which is, and the highlight's going to transfer over, but just bear with me. 800T, nope, that's vacant lot land. I closed that on the other one, but it's the offer to purchase and contract new construction that we just pulled up. So it's either 2T with the addendum or 800T. The big things that this addenda does, now that we've attached it to 2T, we're going to identify who the contractor is, who's building the property. And this is the one, this is if anything needs to be complete, we need to make sure we spell it out here, because this is what's going to override the sentence in 2T that says this property is being sold in its current condition. So what do you have left to do? Do you still have to go through the, put plates on the walls? Do you have to do the builder's punch list, right? Whatever is left, we're just going to spell it out here in additional improvement, so we know that this property is not being sold in its current condition. If it's done, you don't have to do anything here. I'll let you guys go through this. Changes, cost of construction, when things change. Inspections, all buyers should always be encouraged to do an inspection. And that includes new construction. Because you know what? New construction homes aren't perfect. Just because they're new doesn't mean that people build them, people make mistakes. So even new construction homes have problems. Brand new homes they just slapped up are going to have issues. So buyers are always encouraged to have an inspection done. New construction comes with the building deposit frequently. Again, I'll let you guys look at this. We're just trying to get gists.
Those contingencies, could you just put a COO there?
Say it again.
Could you just put a COO for the contingency up there where you were talking about filling what needs to be done?
So what if you haven't gotten the certificate of occupancy yet? Is that what you're
Yeah,
saying?
could you just put COO?
Yeah.
Okay.
Yep. Whatever's left to be done. Yep.
Okay.
So if you're just waiting on that final
Well,
approval.
would a COO cover that for final inspection though, right?
Ask me that a different way. With a COO, you're referring to
All the things you mentioned, like the switch plates and all that, they're not going to get a COO without the switch plates and
once
it's
the
final
permit,
inspection.
right. Once they've come in and said the permits, the work has been done according to permit, that's when they issue the certificate of occupancy.
So could
So
you just put,
I don't know if plates are going to be part of permitted work. You know what I'm saying?
Yeah.
They are. So yeah, if they are or not, right. So if that's all you're waiting on is a certificate of occupancy.
yeah.
I'm not answering your question. I apologize.
I was just thinking a COO would be kind of like a coverall. Because plates
Of what
would
all
not,
left needs
if
to
the
be
plates were
done.
missing, it would not pass final inspection.
Gotcha. So I guess my only hesitation to that, John, is if it's something that doesn't require a permit. Like if something's not complete that does it. Because with permitted work, I've always heard anytime you mess with structural, plumbing, or electricity, you need a permit. So maybe what's something not structural, electrical, or plumbing? Maybe if you still have paint. Yeah. Maybe if something still needs to be painted, then you would do, upon receipt of certificate of occupancy and paint the laundry room.
Gotcha.
Right. Whatever else, that's a great point. But whatever else wouldn't be covered under the wait on that final CO. So you could say CO, but then if the laundry room needs to be painted, then you would want to spell that out, just to make sure we're all in agreement that laundry room gets painted before settlement.
Okay.
Did that answer? Kind of. Okay. Let's see. Building deposit, again, most new construction has a building deposit. Warranties, builders have a implied limited warranty. Get with the builders for specific, not the ocean. Does the house still need insulated? What's the R value of the different insulation? Spell that out. Buyer sign on the left, seller sign on the right. General contractor gets to sign this one as well. If the general contractor's is I'm not the seller. And then we have an acknowledgement of receipt of the building deposit. So the last page 4 of this, as that building deposit changes hands, like the due diligence and the earnest money, we need to acknowledge receipt for that. Other questions on new construction addendum that attaches to 2T or the new construction offer to purchase and contract? When in doubt, find out. It should be, shouldn't it? Let's do one more and then we'll. Here is our FHA and VA financing addendum. This form gets attached to the offer to purchase on the contract when your buyer is getting FHA loan or VA loan. If you don't attach this form, then it doesn't count. This isn't an automatic thing. So there's a section for FHA and then there's a section for VA. So you'll check whichever box. The FHA financing section and this top part of the VA section, guys, pretty much what this form does is protect the buyer's earnest money, even if we're outside of due diligence. So if we find out after due diligence that the home isn't going to appraise and the buyer chooses to terminate because the home didn't appraise for purchase price, they can terminate and they can get their earnest money back. This form is not very popular right now in this market because, again, you got 40 offers in your hand and one of them has an FHA VA financing addendum that says, hey, if I terminate, I get my earnest money back. Sellers are looking at the other 39 offers that don't have this. Does that make sense to you guys? So it might be a discussion with your buyers and their lenders if you even want to include it. You with me? Because sellers may see this as a detriment right now. So it protects their earnest money if they choose to terminate. And then the second part of the VA form, the Department of Veteran Affairs, DVA, may or may not require well water, septic sewer, or wood destroying insect reports to be performed. If required to be performed, such inspections may or may not be required to be at whose expense? Seller's expense. If such inspections are required to be performed and required to be at seller's expense, seller agrees to pay the cost of such inspections. So listing agents, when you get an offer in with an FHA VA addendum, the VA box is checked, you need to make sure you have a conversation with your sellers and let them know they very well may be responsible for paying for the pest inspection, wood, water, septic, sewer. Buyer signs on the left, seller signs on the right. There's very few forms out there that we get to sign. This is one of them. I think part of what we're signing, I think it's up here. Seller, purchaser, and the broker hereby certify that the terms of the sales contract are true to the best of their knowledge and belief, and is agreed that any other agreement entered into the parties is fully disclosed and attached to the sales contract. The parties and the broker fully understand it is a federal crime punishable by fine or imprisonment or both to knowingly make false statement concerning any of the above facts is applicable under the provisions of this title of the code. There's some perks that come with getting FHA VA financing. And what we're all acknowledging is that we don't know of any shady business going on. So in other words, the seller's not trying to sell to the buyer, maybe their family members, and trying to take advantage of those, of the perks of the FHA VA. So when we're signing this, we're acknowledging, we're basically saying this is an arm's length transaction. to our knowledge, the parties are not in cahoots. They don't know each other, and they're not working together to take advantage of this. I was the listing agent once, and a buyer got an FHA loan, and the lender sent me a separate form to sign. Just me, saying that I was not aware of the relationship between the seller and the buyer. So that's pretty much what they're trying, loan fraud, right? It's pretty much what we're trying to avoid here is loan fraud. So one of the forms we get to sign. Questions on this one? FHA VA addendum. All right, so let me make notes so we don't, because I'll try to go over the same form twice. So we did that one, and that one. We did that one and that one. So we'll look at the other one. So we're good. All right. So let's take our break. Let's take 10. We come back. We're going to take a break from forms. Are we ready for a break from forms? Careful when you say that, because we're going to do forms and switch over to math. So careful what you ask for. So when we come back from break, we're going to do our closing disclosure number 2. And then we'll be able to go back to forms. So CD 2 and 10. So it's 236. So let's come back at 247 and we'll do our CD. Okay. Very good. Do closing disclosure. You guys get a chance to look at it. I heard from a couple of you, so I appreciate you reaching out. Chance to look it over.
I enjoy doing them. That was weird,
I'm
but
with, no, I'm with you. I'm shocked to hear somebody else say that. I've never. Thank you.
I kind of like doing them, but if you get off on one little thing, you're gonna get everything wrong.
Yeah.
That's what I'm freaked out about.
Yeah.
So
And that's where practice comes into play, right? Because we learn from our mistakes. So if you can learn from you won't make that mistake again. I hate to kill your Saturday night plans, but don't forget test tomorrow. So if you
what
haven't
time do
spent
we
time
do our test, Julie?
after lunch, you get 3 hours. So I need to start by 2.
Okay.
So do we need to know like the weird stuff for future reference?
Future reference, no. Because remember, in real life, we're not preparing these. Remember, we said last weekend to prepare for your test, if you can do the 5 closing disclosures, including the weird things, you'll be ready for your test tomorrow. But remember, in the real world, somebody else is preparing these things. We're just verifying them. So I think, I get why they want us to prepare them for your exam, because if you can prepare them, then you can verify them, right? So I get them wanting to get that level of understanding. I think a more real world example would be for me to provide you with a false closing disclosure, one with errors, and you guys find those. I think that would be more real world. But again, nobody ever calls me and says, Julie, what do you think we should do? Maybe one day they will, but right now they're not. So, we go with it. So closing disclosure 2. And everybody good, you have a blank closing disclosure for your test tomorrow if you want a couple, if you're worried about messing one up. So I didn't hear from any of you. So I'm assuming you all have the ability to print. And when you come to class tomorrow afternoon for the test, good. You're going to come with a blank closing disclosure and scratch paper. I'll let you have scratch paper too. I just need to see front and back of both sides before the test. That'll be covered tomorrow in my end of course exam rules and expectations. So we'll talk about, there's going to be a check-in process and all that kind of stuff. So we'll talk about that tomorrow, but just get yourself ready and print a blank closing disclosure for tomorrow and have scratch paper. Okay. So we're doing the second one. Little instruction at the top. We're reminded when performing proracing calculations, use a 365-day year. Don't round until the end to the nearest cent. And again, it reminds us you can't get a wrong answer on rounding alone, as long as you don't go overboard with your rounding. Don't just start rounding to whole numbers or tenths or something, right? At least go out to cents, 2 decimal places. So we have on this one a sales price of $433,300. The sales price is one of those things that's a double entry item. Why is it a double entry item? Because it's going to show up 2 times. It's going to show up as an entry to the seller and an entry to the buyer. So if we go on our closing disclosure to page 2, we see the sales price under K as in Kelly 1 for the buyer, due from the buyer. And then we see it again under M as in Mary 1, due to the seller. K is all of the buyer's debits. M as in Mary is all of the seller's credits. So sales price is going to be debit the buyer, credit the seller. Again, that's just what we spent all morning looking at, offered, purchase, and contract. 15 pages to say that. And here we are finally getting a question on the sales price. Where we put it and why. we're closing on September 8th. Again, if you guys have paper in your hand, I think I prefer to write my settlement date at the top of both pages. That's just my preference, because I know I'm going to refer back to that number. I know I'm going to, or that date. I know I'm going to need that. So that's just my preference, September 8th. That way I know I have it when I need it. And then we have earnest money deposit of $1,000. Who can remind me what we're going to do with the earnest money deposit? At settlement, what are we going to do with the earnest money deposit?
Credit the buyer.
Yes. No doubt, but I like it. I want you to do that more often. So what Penelope said, couple of you, it's so funny. Credit the buyer. Remember, the buyer paid that earnest money when we went under contract. Remember, they wrote a check to the escrow agent. So now that we're here at settlement, we need to credit that money back to the buyer. So under L is in Larry, L1, you see a deposit referring to the earnest money deposit, credit the buyer, $1,000. Due diligence fee is also going to be a credit to the buyer, right? Because again, when we went under contract, they wrote that check out to somebody. Earnest money went to the escrow agent, due diligence went to the seller. So now it's settlement, because two people touched it when we went under contract. Two people have to touch it now that we're at settlement. So when we went under contract, it was a debit the buyer, credit the seller. Now we're going to reverse that and do a credit buyer, debit the seller. So under L is in Larry 6, buyer's credits, due diligence fee, $5,000. And then debit the seller under N is in Nancy 7, due diligence fee of $5,000. The due diligence fee at settlement is a double entry. Credit the buyer, debit the seller. We're reversing what we did when we went under contract. Questions on earnest money or due diligence? Financing, the buyer's getting a loan of $366,000. Is the loan amount a debit or a credit to the buyer at settlement? Loan amount, debit or credit to the buyer?
Credit.
Credit, that's right. Somebody's showing up on the day of settlement with money on behalf of the buyer. Who's showing up with that $366,000? The lender. So the lender's bringing that money on behalf of the buyer. So the loan amount is under L as in Larry, L2. Loan amount for 366. On the day of settlement, the loan amount will always be a credit to the buyer. Everybody good with that? The next 30 years will be a debit, right? The buyer's going to spend the next 30 years paying the lender back. But today they're getting that money on their behalf. Let's see, 3.25% interest rate. I got a 2% loan origination fee. Let's look at that one first. Remember, any of the lender charges are going to be of the loan amount, not the purchase price, but the loan amount. What does the lender care about? The loan amount. So all of their charges, all the lender fees are going to be based off of the loan amount. So there's 2% origination fee. So you take your loan amount times 2%. And I get a loan origination fee of $7,320. Lenders are third parties. All third parties entries, everything on page 1 is a debit to third parties. The parties are who? Buyer and seller. Everybody else is a third party. So lender charges are always going to be on page 1. A is in Anna. You have A2, loan origination fee, $7,320. So 2% loan origination fee, and then the seller has agreed to pay 1 loan discount point. First off, loan discount points, 1 discount point is equal to what percentage of the loan? 1 point. However many points you have is equal to that percentage of the loan. So 5 discount points is what percentage of the loan? 5% of the loan. So it's right there in the problem for you. So again, we take our loan amount times our 1 discount point, which shakes out to 1% of the loan. And you get $3,660. The discount point is a lender charge to the buyer. Discount point is a lender charge to the buyer. So who does the lender expect to pay the discount point?
Buyer.
The buyer. So we need to show that amount. We need to show that amount. This part hasn't changed. This is always what we've done, right? That shows that the buyer is paying the discount point to the lender. In this case, the seller has agreed to pay that discount point. This is an agreement between the seller and the buyer. This doesn't affect the buyer and lender's relationship. The seller still has nothing to do with the buyer's lender. So in a sense, when the seller agrees to pay that discount point, they're reimbursing the buyer. So the buyer paid his lender on page 1. Then we're going to go back down to page 2. And I need to give a credit to the buyer under L5. L is in Larry, 5. Seller credit. L5 for $3,660. So on page 1, I'll put this here. On page 1, I did a debit to the buyer. On page 2, I did a credit to the buyer. What did that do to the buyers, what the buyer paid? It canceled it out, didn't it? We did a debit on page 1, and then we canceled it out by doing a credit on page 2. And also on page 2, we need to do a debit to the seller. Again, page 2 is the seller reimbursing the buyer. The buyer pays it, the seller reimburses the buyer. So under N as in Nancy, 8, there's a seller credit on page 2. For $3,660. So at the end of it, how much did the buyer pay for discount points? Nothing. How much did the seller pay? $3,660. Everybody good with what we did? That's a triple entry item, which means you get to see it 3 times.
So Julie,
Yes.
if I miss, that's the one that gets me. If I just put it, if I'm doing what the question says, and I don't do a triple entry, but I'm debiting the
You
seller.
do it here and here.
Yeah. No, I just leave it. I just debited the seller.
Okay.
So it's still going to come out.
Not on this page it is. This page it won't be right.
But on the second page it will.
But on the second
If I
page it
just-
will be.
Okay.
So you're sacrificing the question is what I'm hearing. But I mean, page 1, because you still have a debit to the buyer. And again, the way you can remember that, the seller has nothing to do with the buyer's lender. The lender doesn't care whatsoever about the seller. The relationship with the lender is with the buyer.
Okay.
So the buyer's responsible for paying all of their fees, all the lender fees, period, end of story, always. This is a separate agreement between buyer and seller beside the lender, right? This is something different. So seller agreed. So yeah, we have the debit on page 1 where the buyer pays their lender like we always do.
Mm-hmm.
And then we turn around and reverse that, right? So now you have it canceled out for the buyer and then the debit for the seller. Other questions on that?
Yeah, Julie, on page 1.
Yeah.
At the very top, so you don't carry that across to the seller paid?
No, because the buyer is responsible for paying their lender.
Right, I get that.
Mhm.
But you don't let it show up as being paid by the seller since he offered it.
Because the seller's not paying the buyer's lender. The seller's paying the buyer.
Okay, I got you.
So that's what we're doing. Remember, page 1 is debits to third parties. So that's why, that's a good question. Thank you. So that's why we're doing it on page 2. Again, think of it as the seller reimbursing the buyer.
So, hey, Julie, I get it twice, but why 3 times on page 2? Is it because it's a summary?
Which one on page 2?
The 1% origination point, 3660.
The discount point?
Yeah,
I mean, which entry on page 2? The buyer's entry or the seller's entry? Are you not sure about?
this feels like one too many.
Because it's one more than we're used to doing. We're used to seeing it twice, right?
Right.
So again, on page 1, it's a debit to the buyer.
Right, I get it.
Page 1 is a debit to the buyer. Page 2, we do a credit to the buyer, which cancels that out.
Yes.
So now the buyer isn't paying anything for discount points. And then it's also a debit to the seller under N is in Nancy.
The way I do it to make sense to me is you got to remember that we're just doing a tally of a single check that we're going to write to the attorney and the attorney's disbursement. We're not sitting there passing out checks back and forth.
Right. We're not handing money around. Right.
Right.
Yep.
Thank you. I think what you said something that kind of jived with me. Essentially, it's a wash. So it's only one transaction.
That's
The seller's
exactly what
being
it is for the
charged.
buyer, Arion. It's a wash for the buyer.
It's
Yep.
a wash.
Yeah.
But we have to show it because Uncle Sam needs to know who's paying whom,
There
essentially.
you go. There you go. And it's a lender fee, right? So the lender on their books need to see that the buyer paid that to them.
Right.
Think about their books. They need to see that this money came from the buyer. The lender doesn't care that the seller has agreed to pay their discount points. All the lender cares about is the buyer going to give me this discount point, right? So their books are okay on page 1. And then on page 2, the seller's reimbursing the buyer, pretty much is what we're doing here.
Okay.
So yep, it's a wash for the buyer. That's exactly what it is.
Okay. Thank you.
Mhm.
Not that we didn't discuss this last time.
I get it. Like you said, it's like it's on there one too many times. And it is, because we're used to seeing double entry, and now I'm busting out with a triple entry item, you know? And by the way, you guys, I feel the need to tell you this. Paralegals and attorneys have software and programs that they just plug numbers in, and they plug the numbers in, and it beep, boop, boop, and it calculates into the closing disclosure for them. So don't you think they're sitting around doing these themselves either. I had a paralegal in pre-licensing once, did this for a living. And for the life of her, she could not do these closing disclosures because that's not what she did every day. She just sat there and punched numbers in and let it populate. It's like, honey, this is what you do for a living. How can you not?
One
We
more
got
reason
it.
for us to not have to bother with this.
But we got to verify. That's I'm standing behind. We got to verify it. All right, everybody good? When the seller agrees to pay either the discount points or the loan origination fee, triple entry item. Can I erase the red? Everybody have my math? Okay. Let's see, commission. Commission is 5% of the sales price. So our sales price is $43,300. Seller has agreed to pay 5%. Total commission is $21,665. We'll split that between the sides in the real world. Here, we're just looking at the big picture. So 5% of the sales price. Note, at closing, the listing firm will retain the earnest money as part of the brokerage fee. Go back up in the problem and we're reminded earnest money is how much? The earnest money deposit was $1,000. So from the total commission, we need to deduct $1,000. And on page 1, debits to third parties, the amount of the check that the real estate firm is going to receive is the total commission minus the earnest money deposit. So firm ABC, when you go pick up your check, it'll be $20,665. We are third parties. So the amount of our check goes on page 1. Isn't the seller contractually obligated to pay $21,665 though? Don't they have an agency agreement out there saying they're going to pay the $21,665? So in addition to the amount of the check that the firm is going to get, we also need to come back down another debit to the seller. N is in Nancy, N1, excess deposit of $1,000. So the seller has paid the full commission. Most of it went to the firm. The rest of it was just a debit to the seller. And this did not change the fact that the earnest money was credited back to the buyer at settlement. We still did that. That'll always be the case. So now, after settlement, you get your check from the attorney's office for $20,665. You take that back to the firm. The firm has the $1,000 earnest money sitting in their trust account. So they transfer the $1,000 from their trust account to their operating account. And from the firm's point of view, how much now do they have in commission? Once they transfer that earnest money deposit, now they have the full commission. It is on mine. It might be somewhere else in N. So I don't care where in N you put it, just get it in N. Questions on this? This is when the real estate firm is holding the earnest money.
That's what,
Robert?
yeah, I was just gonna say, you can't do that if it's deposited into the attorney's account.
That's right, because the attorney already has it, so it's
Right.
already there, right?
Yeah, I mean, you can't put it
But
under,
they'll transfer that from their trust account to the escrow account. So this is only going to apply when the firm, the listing firm will retain the earnest money as part of the brokerage fee.
So this too is a triple entry then.
Yeah, I guess if you want to count the credit to the buyer. Yep. But that credit to the buyer doesn't change. There's absolutely nothing different about that.
Mhm.
What other questions on that do we have? Okay, very good. Can I erase the red? Seller's loan payoff on the date of settlement. They still owe their lender under N as in Nancy 4. $397,512. Pay off a first mortgage, pay off a second mortgage, pay off a third mortgage, pay off a fourth mortgage. Seller's got to pay it off due from the seller at closing. N4, $397,512. Let's see, then we got homeowners insurance annual premium. That's for the buyer. That's for their new insurance policy that starts the day of settlement. So we're going to come back up to F as in Frank. F1. It's a prepaid. If we're going to settlement on September 9th or 8th, what is it, September 8th? They're prepaying their insurance from September 8th this year to September 7th next year. They're prepaying for the full year. So let's put years in here. Let's pretend that this is 2022. And so next year would be 2023. They're prepaying their homeowners insurance for the first year. So they're covered for the first year. And they're going to do that at settlement under F as in Frank 1. And that amount is $1,250. Private mortgage insurance is conventional loan. This lender's charging PMI premium for the first year, $1,174. Under F as in Frank 2. Again, they're prepaying PMI for the first year. So F2. Property taxes for the year have been paid. So let's see what that looks like. So we got our taxes for the year. Year being January to December. Oops, you guys know what that means, right? With the dividing factor, what divides the year? The day of closing. Seller owns the property the front part of the year. Buyer owns the property the latter part of the year. Taxes have been paid, which means the seller has already paid the entire year's taxes. The tax bill for the year is satisfied by the seller. So at this point, we stop and ask ourselves, who owes whom? Put yourself in the seller's shoes. Don't you want some money? So who owes whom? This is going to shake out as they debit the buyer, credit the seller. Let's put this down here. The buyer owes the seller for the period of time they own the property. Do I have everybody so far? The buyer owes the seller for that period of time. Who pays taxes on September 8th? Whose responsibility are taxes on September 8th?
So
Seller. Yep. So that means buyer starts paying taxes the day after. Yes. So the day after closing to the end of the year. This will take us a second, but in order to get it right, we're going to count September 9th, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, and 30. There are 22 days left in September. Don't look at that and see 21. Count it out on your fingers. There are 22 days left in September, 31 days in October, 30 days in November, and 31 days in December. Remember, you guys, tomorrow I'm going to give you the days of the month. I don't want that to stress you out. I'd rather you get stressed out about something important than how many days are in November, right? So I'll give you the days of the month tomorrow on your exam. So you add it all up. And the buyer owes the seller for 114 days. Is that right? 22, 31, 30, and 31. Yep, 114 days. Everybody good on how I got the 114 days? I literally counted on my fingers. I suggest you do the same. Now we got to figure out how much. So we're told annual taxes are $57.68. How many days in a year? 365. So you take your annual taxes divided by 365. What calendar year am I in? And we get like $15. They say go to the third, so let's do 803. Go out further if you want to. But if you always go to the third, you're going to be more accurate. Each day, taxes are $15.803. We've already decided 114 days. So it's found out, it's discovered that the buyer owes the seller for their portion of the taxes, which is going to be $1,801.54. We've already determined that's going to be a debit the buyer, credit the seller. So we're going to go to page 2. Buyer's debits are K, seller's credits are M. So in K, somewhere in the taxes, again, in the real world, it's going to be split out, city, county. They don't do that to us on the test. See, they do take some kind of pity. So 1801.54, debit the buyer. And then 180154 credit to seller. The buyer is paying the seller back for their portion of the taxes. Questions on, I like drawing the picture. The picture helps me see the seller's responsibility, the buyer's responsibility. And I'll be honest with you guys, for me doing property taxes, the thing that gives me the biggest problem is figuring out debit to whom, credit to whom. So if I just stop and just think about that, I got my picture, I know the taxes have been paid. So then I just stop and ask myself, who owes whom? If I'm the seller and I paid the taxes, I want some money, right? The only person to pay me is the buyer. So debit the buyer, credit the seller. What questions do I have on that? And can I erase? Everybody good? Or wait a minute, Julie. Okay. We got some loan escrow deposits. We're gonna have to go back up with the problem, get some information. The lender wants to collect, where'd it go? 3 months of real property taxes. So we go back up in the problem, and we're reminded that our annual property tax is $57.68. That's annual, and I want to break it down to monthly. So I divide by 12. 57.68 divided by 12 is about 480.67. The problem tells us they want 3 months for escrow, for that cushion, that reserve. Again, everybody's expecting taxes to go up next year. Just happens. Two months of homeowners insurance premium. So again, we got to go up just a bit. Scroll up. $1,250 is our annual insurance. That's annual. Divide by 12 to get monthly. And the problem tells us they want 2 months. The lender wants 2 months. So they're going to collect $208.33, again, banking on that going up next year. And then they want 2 months of private mortgage insurance at a renewal rate of $75 per month. So the next year, they're not going to charge the same amount as PMI. The next year, they're going to charge less because they're less of a risk to the lender. So if each month is $75, they want to collect 2 months. For PMI, they'll collect $150. So back on page 1, G is our initial escrow payment at closing. Buyer's going to pay $208.33 for insurance. Escrow $1,442 for taxes, escrow, and then $150. And all this is under G, as in Ginny. Originating the escrow account and putting a little bit of cushion in here just in case those bills go up next month. So the lender can still pay them on the borrower's behalf. Questions on escrow? deposits. Our credit report fee and our appraisal amount are paid outside of closing. So if you want to put these on here, they're under B, as in boy. If you want to put them on there, that's fine. Just make sure you get them in the right place. Put them in the buyer paid before. And I told you guys the other day, that's where your error is on the solution sheets that you guys have in Learn, Test, Pass. They charge the buyer. But they're paid outside of closing. Credit report fee and appraisal. Can I erase the escrow map? Everybody have this? Everybody good?
Hey, Julie, under B,
Yeah.
you got $45 in the appraisal and it's 3
Yeah,
cents.
I do, don't I? Gotcha.
Okay. Not that it's
You're
a
with
big
me
deal,
there.
but us trying to learn, that's confusing.
Yep. Just because I saw that one first. Thank you. And then we have miscellaneous expenses charged at closing of the respective parties according to standard practices indicated. Interim interest. Let's talk about interim interest. Again, let's draw a picture. You see prorating taxes, draw a picture. You see interim interest, draw a picture. Why don't you guys tell me in the chat while I'm drawing pictures? If we go to closing on September 8th, when will the borrower's first mortgage payment be due? We go to closing on September 8th. They have a mortgage payment due when? Yep. You guys and your question marks. I'm about ready to ban question marks and pre-licensing. If I could figure out how to not make that key work for you guys, I would. So, so it looks like we're good. If we originate the loan on September 8th, there is no mortgage payment on October 1st. Remember, whenever you originate a new loan, you always skip the first. So I think I heard from all of you, at least the ones that I heard from, you gave me November 1st. So you skip the first. The first mortgage payment is due on November 1st. When you make your first payment on November 1st, you're paying October's interest because interest is paid in arrears. So you're paying the previous month's interest, which means at settlement, the lender's going to collect interim interest. Interim interest is always from the day of closing to the last day of that month. Interim interest is always, y'all hear my absolute word there? Is there a wiggle room to always? No. Interim interest is always the day of closing to the last day of that month. Now we need to figure out how many days. What's the magic formula? I see Donna going, so I'll let her. Did I make you lose count? I'm sorry. So you whip out your fingers, right? You count it out, and you're going to get 23 days that the buyer owes. Counting, you count the 8, 9, 10, da da da. Everybody good with counting on your fingers? I'm the only one watching you. I have zero judgment because you know what I do? I count on my fingers. No shame whatsoever. Okay. So everybody good with 23 days? Then we got to figure out the amount. To figure out the amount, you always take the balance. The balance is the loan amount. Remember, oh no, don't do that. The lender, this is a lender fee. This is a lender fee. So the lenders only care about the loan amount, right? They don't care about the purchase price. The lender cares about the money that they're bringing, the loan amount. So you take the balance, which is the loan amount, which is $366,000, times the interest rate, which I forgot to look at that when I was just up there. So hang on. So the loan amount of 366 at an interest rate of 3.25%, back up in the problem. So the balance times the interest rate gives me annual interest. There we go. Balance times the interest rate gives me annual interest. And I need to break annual interest down to daily. So I'm going to take annual, divide by 365 to get daily interest of $32.59. Balance times the interest rate gives us annual interest. Annual divided by 365 gives us daily.
Hey, Julie.
Yeah.
Can you tell me where I went wrong? I got 22 days because I did not count the 8th since the homeowner buyer did not have possession of that day, the home that day.
The only time the seller is responsible is when I'm prorating between the buyer and the seller. I'm not prorating. This is interim interest between the buyer and their lender.
One thing that helps
So
me
the
remember that,
buyer owes interest the day of settlement. Sorry, John.
Robert, one thing that helped me remember this, because I asked you the same question the other morning, Julie, is with the interest that's paid to the rear. So you can think of it as they took the property on the 9th, but they paid to the rear the day before. So if that helps at all, it's their
It
property on
does.
the 9th, but they paid the interest on the 8th.
It does.
Okay.
They paid to the rears.
And I was just
Because
sitting there
that's
telling,
when the loan was originated, right?
yeah, and that's what I was just sitting there telling myself too, that the money was given to the buyer on the 8th. So
That's
that
right.
remember it
There you
too.
go. There you go. And put yourself in the lender's shoes. If I'm giving you $366,000 today, do I want to be paid interest on it? Heck yeah. Right. So again, interim interest is not between the buyer and the seller. We're not prorating. This is between the buyer and his lender or her lender, their lender. Okay, everybody good with that? 23 days, buyer owes the lender interest. Balance times the interest rate annual, divided by 365. Daily interest is $32.59. We just said 23 days. So the buyer, whoops, owes their lender for interim interest for $749.55. Interim interest goes on page 1. It's a prepaid. They're prepaying their interest. F is in Frank, 3. Questions on interim interest? Questions on anything so far? How's everybody doing? You guys hanging in there with me? Cool. Okay. Yeah. Robert, do you have a question? Nope. Okay. Just being sure. All right. Let's go ahead and take our break. Everybody take a stretch, clear your mind for a minute. When we come back, we're going to finish this up. So let's take 10. Time is 3:37. So we'll come back at 3:48. Okay, so I am, as you guys are coming back, I'm putting in the chat. You guys remember that worksheet I shared with you guys last class? It's weird, I just did it. I'm trying. That who pays for what? I was going to try to give it to you again in the chat, but for some reason it's not allowing me. Okay, there it is. I'm looking at it, but when I try to attach it to you, grr, technology. Here it is. Here it is. There. So there's that guide, we'll call it. So you guys can grab that, download it. Again, that's half the battle of this, right? As knowing what's a debit to whom, credit to whom. Donna, if you need me to email it to you again, just shoot me a message. I don't know why you can't see it. Because it's technology. That's my answer. Technology. It's great when you want it to work. If you want it again, just reach out to me and I'm happy to send it. Okay. Let's see. Robert get kicked out. He's coming back. Welcome back. So while you were gone, I gave him that worksheet again. Who pays for what? Do you still have it or do you need it again? You got it? Okay. All right, cool. Cool. So, again, test is tomorrow. So that you can't use that on your test tomorrow.
Hey, Julie, can you resend it to me? I apologize. I don't have what you're talking about. I'm sorry.
So, let's see. Remind me, I'll put it back in the chat. Or shoot me an email and I'll reply after class. Yep. That's the other thing I learned about chat. If you're not on, you don't see previous chats when you come, right? Like you only see chats from when you, so I know more about Zoom than what I probably should, honestly, but we're figuring out as we go. All right, so we've made it through interim interest. Questions on anything so far? Is this helping to go through it again? Kind of revisit these things? That's one reason why I like to do it when I do a weekend class. I don't want to do both of them last weekend because then you got a whole week to forget about it. So hopefully by doing it this weekend, it's triggering some things and reminding you. Title insurance. Guys, remember, this is, thank you, Jordan. Robert, she put it back in there. Thank you. Because I struggled with it so much. So Jordan helped me out and make it easier for me. So thank you. So title insurance, guys, remember, and you may see a practice problem that refers to title insurance as the owner's policy. It's referring to the new owner because who is title insurance protecting? Today, they're the buyer. Tomorrow, they're the owner, right? So title insurance, the owner's policy is for the buyer. There may be a lender's policy. The buyer gets to pay for both. This particular problem just lumped them all together and called them title insurance. So if we go back up under C as in cat, C3, buyer pays for both the lenders, if the buyer's getting a loan, the lender's policy and the owner's. Buyer hires the attorney, so they get to pay the attorney's fee, still under C, C1. Contract says who pays for deed preparation? Who did the contract tells us going to pay for the deed preparation?
Seller.
Seller. Yep. Yep. So under C is in cat 2, deed preparation, we're going to go to the seller's column. I'll go up so we can see it. Seller paid at closing, deed preparation, $95. Recording fees, deed and deed of trust or mortgage, the buyer gets to pay. So under E is Elizabeth, you have a deed recording fee of $15 and a mortgage or a deed of trust. Like I said, in North Carolina, we're just fancy. We call our mortgage the deed of trust, so it could be either one. For total buyer to pay at settlement, $39. Who does the contract tells us pay excise tax? See a couple of your mouths moving?
Seller.
Seller, yep, seller pays excise tax. This is the one that's based off of the purchase price. So the seller's fees are typically off the purchase price. So our purchase price is $433, $300. Is that number divisible by 500? If you were to take 433, 300 and divide it by 500, are you gonna get a whole number? And you're not. You can try it right now if you like. 433, 300 divided by 500, you get some change. Excise tax will always be a whole number. So when your purchase price is not divisible by 500, then you have to round up, always up, to the nearest 500s. Now, do I have a number divisible by 500? Let's see on our calculators, 43,500 divided by 500. And we get excise tax, goodness, of $867. Purchase price has to be divisible by 500. If it's not, make it divisible by 500. And you always round up. This is the government that we're talking about here. Never ever round down. Always round up. I apologize if I have any government employees on the call. I'm certainly not saying anything, but it kind of is what it is. Yes. $867, debit the seller. Still on page 1 under E is in Elizabeth. E2 is excise tax. And there's a fee for the seller for excise tax of $867. Pest inspection. C4, C is in cat. Goodness. That pest inspector is proud of his inspection or hers for $120. Survey, C is in cat 5, $450. All part of the buyer's due diligence, so they get to pay anything in connection to their due diligence unless we're told otherwise. Can I erase the excise tax math? Anybody have this? Okay. And then last up, home warranty be paid by the buyers. That's going to be a debit to who? Debit to the buyer. So it should specify. So come here under H. H is in Heather. Buyer pays the $450 home inspection fee. Let me give you guys just a couple minutes. Let me give you like 5 minutes. And I want you guys to add. You should have this, or I mean, I can let you show mine, but I have to scroll with you. So hopefully you've been working along with us and you can add. Figure up your tallies. Let's break this down into 2 different things. So first, let me give you like 3 minutes. I'm replanning my game here. Let me give you like 3 minutes. You guys add up page 1. And in about 3 minutes, we're going to talk about the buyer's J and the seller's J. Just worry about page 1 right now. And I will scroll up. Here's the top half of page 1. And then I'll scroll down in a minute so you can add up the rest. And if you want to tell me your answer in the chat, just do so in a private chat so you don't give your answer away to everybody. So here's the bottom half of page 1 if you're so everybody get something for page 1. So let's just recap. You're finishing up. Let's look at the buyer paid at closing first. Remember, in the real world, these are going to be done right, where they're going to tally up A, they're going to tally up B, they're going to tally up C. They're going to tally each section and then add them all up here at the bottom. Julie's a rebel. I just straight line add down. To me, that's the easiest way to see it. So make sure top to bottom straight line adds. So I got my loan fees, my discount point, my origination fee, attorney's fee, title insurance, pest inspection, survey, recording fees. There's our prepaids, first year homeowners insurance, first year's PMI, a prepaid interest, our interim interest. You got your escrow amounts, 208.33. Mortgage insurance, 142. Property taxes, I think I got those backwards too. Yeah, mortgage insurance should be on top, 150. Property taxes, and then your home warranty of 450. So when you add up everything in J, you're getting buyer's J, I should say. You're getting roughly, give or take, $18,536.88, give or take. If you're a few cents off from me, it's because of rounding. You can't miss by rounding alone. Test 1, or one test question. One test question. What is the buyer's J? So now we're going to add up the seller's J. Again, just to recap, you have the deed preparation fee, excise tax, and then your earnest money minus the $1,000. So you add up the seller's J, you get $21,627. That is your second test question. What questions do I have on page 1? Debits to third parties. I think as soon as you get the J's on page 1, I think you should take both of those numbers and immediately put them on page 2, so you don't forget about it. So you got your buyer's J and your seller's J. Go over to page 2. K is all of the buyer's debits that include J from page 1. So we're going to take that 18,536.88, put it under K as in Kelly, K3 for the buyer. And then the seller's debits are N as in Nancy. You're going to take that number from page 1 and put it in N as in Nancy 2. So now we are officially done with page 1. We no longer have to worry about page 1. So now what I just throw it out the window, right? Tim's done. I'm done with this. Okay. You're almost done with page 2. That's the good news. So now I want you guys just to focus on the left-hand side. Don't worry about the seller right now. Just focus on the buyer. Remember, all of the buyer's K's, everything in the buyer's K is their debit. Everything in L is their credit. So you want to add up all their debits, add up all their credits. Debits minus credits tells us how much the buyer has to bring to closing. So K is in Kelly, is all the buyer's debits. L is in Larry, is all of their credits. So if you look at all the buyer's debits, the debits include the purchase price of the property, that number from J that we got at the bottom of page 1, and in this problem, their portion of the annual property taxes. Then we look at all the buyer's credits. We got their $1,000 earnest money, their loan amount, the credit that they got from the seller for paying their discount points in this problem, and their due diligence fee. When you add up all their debits, you get about $453,638.39, give or take. You add up all their credits, you get $375,660. No change in that one. Debits minus the credits. Tells us this buyer has to bring $77,978.39 to settlement exactly. Cash to close from the borrower. That's your third test question on the closing disclosure. Questions on the buyer side, the left-hand side. Everything in K minus everything in L. And then the right-hand side is the sellers. M as in Mary are the seller's credits. N as in Nancy are the seller's debits. So credits minus debits will tell us hopefully how much the seller's gonna get from closing. Were you like a few cents off or way off?
I got 78,023.39.
Say that again, 78, 20, 39.
78,023 and 39 cents
All right,
on
hang on.
cash to close. I don't know, maybe I'm subtracting wrong. 'Cause
You're
I've got-
off $45. Where did you put the credit report fee on page 1? Well, then you would have gotten page 1 wrong too.
Hmm.
Did you put that under buyer paid before? On page
No,
1?
before, yeah.
Before,
I
okay.
put on B2. I don't know.
So you're off by $45. That's why I thought that first, because that was that amount, but then you were wrong on page.
That's crazy, but anyway.
Are your numbers here on page 2 match up with ours?
No.
Did I just see a light bulb? We'll go back up to page 1 in just 1 second. Hang tight. We'll go back up in just 1 second. Seller side, M as in Mary is all their credits. So you got a purchase price of $43,300. Their portion of the taxes, what the buyer owes them for their portion of the taxes. And then N is in Nancy is all the seller's debits. So there's that $1,000, that extra $1,000 that they still owe for commission. It's in the listing firm's escrow account. There's this closing cost that we got from page 1. Payoff of their first mortgage, due diligence, and then the seller paying for the buyer's discount points of $3,660. So we add up all of the seller's credits. We get 435, 101, 51. We add up all the seller's debits. These guys are close, aren't they? 428, 799. I don't think they own this home for long. It's kind of what it looks like to me. But something's better than nothing. So at settlement, they're going to get $6,302.51. And that's going to be your fourth test question. This kind of problem is a good reminder to me. Real estate was never meant for short-term investment. It was never designed for short-term. I mean, their loan amounts almost $400,000 too. What do you think? Is that what you guys got for sellers? And a couple of you chimed in on the chat. Let's see 9 thumbs ups if we're good for the sellers. Okay. Okay. Cool. 302. Yeah. Good. Is everybody good? Good. Donna, did you find your $45 yet? This is what I was thinking right here, because that credit report fee is $45. So I want to make sure you got that in the right place. Did everything add up for you on page 1? It's 18,536.88-ish. So you got page 1. So where you're off is somewhere on page 2. Was it just a human error on the calculator? That happens too. I know.
All
from
right.
experience.
So
Find it.
down at the bottom, it's 453,683.39, right?
Mm-hmm.
Minus.
No. I'm seeing
Is that
no.
what I'm doing?
What did
What am
you?
I doing? Is that where I'm off?
Should be 453,638.
She said
39.
83, didn't she?
Yeah.
Ah.
Dyslexia just got us all. Yep.
Hey, Julie,
Yeah.
Julie,
Yeah.
the actual answer sheet has 453,683.39.
Oh, it does. Yes. That's where I got it.
Remember
But
though, the answer sheet, that's what's going, the answer sheet, this $45 is in the wrong place.
Ah,
So if you're looking at the answer sheet, learn test pass, the $45 is here, which is throwing it
Okay.
off.
okay.
So this is all making sense now, isn't it? Why you're off by $45 is back to arguing with this credit report fee. So
That's it. Okay,
'cause
got
it's
it.
paid outside of closing, and that's where they went wrong, is they put it in the wrong column.
So what's the
So-
Bible for tomorrow?
Was 3,400. No, don't write that down. So that's good. That's good, Donna. Thank you, Robert, for. Okay. Then you guys, I think we're kind of learning here, right? It's hunting and pecking. You know, if you put something in G7 and it's supposed to go in H6, this bottom number is still going to work out, right? So as long as you debit to third parties go on page 1, and then your buyers debits and credits, sellers credits and debits on page 2, the bottom numbers are good. I don't need to see your work. I don't need to see your calculations. I just need to see A, B, C, or D. Okay. So as long as you get them close enough. Again, for your test tomorrow, it'll be 4 different answers, or 4 different questions. I'm sorry, 4 different questions, but the entire closing disclosure is on all 4 questions. So as you go from question to question to question, you're going to see all of this information. Does that make sense? So they're going to say, like, number 36 wants to know the buyer's J. And it's going to give you all this. 37 is going to want to know the seller's J, and it'll get, so every of those 4 that you're looking at the information. So you'll be able to, my suggestion is go through and do the whole thing and then answer the test questions A, B, C, or D. Questions? So 6 test questions tomorrow on math. 4 of them are closing disclosures. 2 of them are proration problems. So if you feel like you can prorate, I mean, there's 2 extra problems right there for you. 6 total. You can only miss 10. And you got 3 hours. So you at least try the math. See what you get. Questions or comments? Concerns? I always have concerns when I do math. Breathe, take your time. Do you guys have a calculator? Remember, I cannot let you use your phone tomorrow. Look at you guys. There you go. Great. No phones tomorrow on the test. Why? Because your phone has Google. So I can't let you use, I can't let you use your phone. Perfect. Good deal. Yep.
Hey, Julie, I'm asking, will that one work, or do I need to bring my just basic calculator?
Let me see. Come, pull it up. Yeah, that one's fine. That one's fine. Yep. All right. We got a few more forms to look at, but we'll look at those tomorrow morning. Just a couple more forms to look at. I feel like we're kind of formed out for the day. So let's just kind of go back. This would be a good refresher on things that we talked about this morning. Again, your standard form 2T was our the big show of chapter 11, the highlight of chapter 11. The pages in your books that correspond for the most part with the offer. Some things the offer might have updated since the book's been published, but I also want to make sure you guys remember the guidelines for completing standard form 2T, because when in doubt, it's another good resource to help you make sure that you're properly filling it in. So now what we're going to do, we're going to talk a little bit more about the earnest money. There's certain rules, certain things that we need to understand. So let's take a few minutes and talk specifically about the earnest money deposit. And we're back in the book on page, 335. That section actually goes into very in-depth detail about your earnest money. Remember, the earnest money deposit is a negotiable amount. Whatever the buyer's willing to offer and the seller's willing to accept. There is no set amount. So it's part of the terms that we negotiate. Earnest money, this tends to be a source of confusion. Earnest money is not an essential element of a valid contract. You can have a legally binding contract with 0 earnest money. Remember, whatever the buyer's willing to offer and the seller's willing to accept. So if the buyer offers 0 and the seller accepts 0, that's the term that they agreed to. That's the term that they came to understanding. The whole point of the earnest money deposit is to show the buyer's good faith. The seller wants to know that it's a serious buyer. Again, the seller's got to move out. They got to make arrangements for somewhere else to live. They don't want to make all these plans just to have a wishy-washy buyer, right? So the earnest money helps show, well, you even bypassed my waiting room that time. Must not have fully kicked you out. So the earnest money deposit just shows the buyer's good faith and that they're serious. And remember, you guys, the earnest money along with the due diligence fee are the seller's liquidated damages, and the seller's liquidated damages are their sole and exclusive remedy. if the buyer or their home inspector or their agent or their appraiser damages the property, that's about the only time the seller can sue the buyer. If they damage the property and they're not willing to pay for that damage, then the seller can sue, but they're not suing for the buyer breach. They're suing for the buyer that damaged their property. As we said, the earnest money on the contract, page 1, you have to select. The earnest money is either due with this offer or within 5 days of the effective date. You choose which one. The escrow agent has to deposit the earnest money within 3 banking days of receipt or contract formation. So if you're being asked to hold the earnest money deposit for the buyer, while you're negotiating the offer, you don't deposit that check until you're under contract. It's provisional brokers, get that check to your BIC. You go under contract, your 3-day clock starts at contract formation. If you go under contract and then they hand you an earnest money check, your 3-day clock starts from receipt. So it's 3 banking days, Saturday and Sunday not included, from contract receipt or contract formation. Ariane, do you have a question?
No,
No.
Sorry.
Okay. No, you're good. Just don't want to miss anything. Again, the broker, the full broker, notice that says broker, that does not say provisional broker, right? The full broker can hold earnest money during negotiations. If it never becomes a contract, if the contract is never formed, we need to get that check back to the buyer or destroy of it according to their instructions. I've only had this happen once, and I'll tell you guys, I had buyers come in from Florida for like the week. They were here Monday through Friday. So I spent Monday, Tuesday, Wednesday, Thursday showing them property. Friday, we went back out and looked at the top 3. And about the time he was getting on a plane, I was writing an offer for him on the one that he decided. Spent all week together. It's actually a pretty fun week. Before he got back on that plane, he handed me 2 checks, one for the earnest money, one for the due diligence. Because they were strong. They were both good, different markets. So they weren't like $50,000 strong, but in the market at the time, they were both good checks and he felt pretty sure about it. He handed me 2 checks. He got on the plane. I wrote his offer up. He landed, signed it. I presented his offer. Seller accepted. He was still probably trying to drive home from the airport when we were under contract. It was amazing. If that offer had never gotten accepted, I had both of those checks in my hand. And he and I had a conversation about what I was going to do. I was going to write void on them, and I was going to take a picture and show him so he could see that they had been voided out. But he knew he was in Florida. He knew these checks were due. So he left them with me on his way to the plane. Does that make sense, everybody? So you might have an out-of-state buyer that why you would be hanging on to their checks during negotiation. If he had not have done that, and we went under contract, he would have had to overnight them to me, because the contract says the due diligence is due when? By the effective date. By the due diligence is due by the effective date. So this was a conversation he and I had during our week together, along with his 3-year-old son, his dad, and his wife that was 5 months pregnant with twins. It was a fun week. I didn't plan enough potty breaks the first day, by the way. I didn't know the wife and the son were coming. So I gave us more time on Tuesday, Wednesday, Thursday. Provisional brokers cannot walk around with somebody else's money. Full brokers should not. This is why you have a BIC. This is why your BIC gets paid the big bucks. Let them be responsible for it. But y'all don't tell them I said that, okay? We'll keep that between us. If the seller breaches, the buyer can sue. And some things that the buyer can sue the seller for. Earnest money, due diligence, money already paid or accrued as part of the buyer's due diligence costs. Maybe they've had the home inspection done. They haven't paid for it yet, but it's been done, so they owe that money. The appraisal, the survey, the pest inspection. Remember, the buyer can also sue the seller for specific performance. When you see performance, see the word perform. If the buyer's suing the seller for specific performance, the judge could make the seller sell. The judge could make the seller perform. Think we're good on this. Buyer terminates within due diligence. Seller's going to keep the due diligence fee. Buyer terminates within due diligence. Who gets the earnest money? And I can see your mouths move. Buyer terminates within due diligence. Who gets the earnest money? Huh. Maybe you guys should tell me in a chat. Hear what I'm saying? Buyer terminates within due diligence. Who gets the earnest money? And it's the buyer. There you go. There you go. It's the buyer. Buyer terminates within due diligence. Seller keeps the due diligence fee. Buyer gets their earnest money back. Buyer terminates after due diligence. Now the seller gets everything, right? Seller will keep due diligence, and now they get the earnest money. Is everybody good with that? No more doom and gloom. What if we make it to closing? We talk about what if we terminate? What if this doesn't? But sometimes they make it to closing, don't they? So when they make it to closing, both due diligence and earnest money are going to be credited back to the buyer at settlement. And that's part of what we worked out under L on your closing disclosure with all the buyer's credits, their earnest money deposit and their due diligence. Remember to debit the seller the due diligence. They've already received it once. They should not receive it again. I think we've said this a couple times now. PBs must deliver. If you're in the throes of negotiations, they say, hang on to this for me. PBs have to deliver to their BIC. Full brokers should deliver to their BIC. The only exception to this rule is if earnest money is in cash. You always get cash in the bank right away. So if you're in the throes of negotiation, your buyer hands you $5,000 in cash and says, hang on to this for me, get it in the bank. If your firm's policy allows you to collect cash, I would strongly encourage a cashier's check, money order. I think we all know what kind of bad things can happen with cash. But if you got cash in your hand, if you got a check in your hand, it's your responsibility. So if you're in throes of negotiation, they hand you cash, get it in. Because if the contract's never formed, I can turn around and write a check out. I don't have to wait for cash to clear the bank. It's in. Commission rule allows us to handle other money. So for example, at some point, we'll have the due diligence fee in our possession. We're acting as couriers. We're delivering it from point A to point B. So we can accept due diligence fee option money for the purpose of delivering it. So we said it's in our possession. Let's say you meet your buyer, you go under contract, yay, your buyer's agent, and you meet your buyer to get the due diligence and the earnest money. You say, all right, we're going to go to dinner here in about an hour. So I'll just meet you out there in the parking lot, wherever, and I'm going to get those checks from you. You get the checks, they're in your hand. The buyer calls you and says, do not deliver them. Do not deliver these checks to the listing agent or the seller. I have to follow the buyer's instructions. So if they tell me not to deliver, I say, are you sure? And this could be an out for the seller, and maybe they could even sue you. And the buyer says, no, no, I don't want you to deliver those checks. It's their money. And I have to follow their instructions. What comments do I have on that? That's a deep one, isn't it? Remember, I'm just acting as a courier. I have no control or responsibility over this money whatsoever. So if they tell you, don't you deliver it. Tell them they could be in breach and it could cause the seller to sue. But they say, I don't care. I don't want you to deliver it. Then you don't. You get it back to the buyer or you destroy it as they tell you. We said earlier, if it doesn't close, both parties have to release the earnest money. And if the earnest money is in dispute, then the escrow agent hangs on to it until we come to a resolution. And after X amount of time, the escrow agent can turn it over to the clerk of courts and let the two go hash it out in small claims courts. The escrow agent can't make a decision about what happens to the earnest money. Everybody good on this? Questions on anything with earnest money? I would like to take you guys back out the commission's website real quick and show you just a couple things while it's fresh on our brains. No, it's under publications, that redundant, publications. And we looked at a couple of these Q&A brochures last weekend. I think we looked at offer and acceptance, and there was another one. Home inspection. Just to let you guys know, there are also Q&A brochures, one about due diligence and one about earnest money deposits. So if you guys are working with buyers, especially in this market, you may need help explaining due diligence and earnest money to your buyers, because they're very confused right now. They're very confused right now about how they're supposed to compete with $50,000 due diligence and earnest money. I get it. I'm confused too, trying to explain it to them. But I think these Q&A brochures in the Real Estate Commission's website, it helped explain their purpose, especially this due diligence. What kind of inspections do I need? Let's see. Oh, it's a due diligence period. But I think if we look, all sorts of good stuff here, huh? No, so they don't talk about the fee. I apologize. But the earnest money talks about, so yeah, due diligence. Again, use these. These are good tools for us to use, for us to utilize when you're working with buyers. Y'all stop trying to recreate the wheel. You guys are exhausting. I'm going to find a new way to explain due diligence. Why? It's right here. It's in your contract. It's on your forms. It's in your resources. Fair enough? Trying to help you guys out a little bit. Use this stuff to help guide you. We're nearing the end. We keep plugging along at chapter 11. We'll plug through this a bit this evening. So yeah, tomorrow we'll pick up where we left off. We'll look at the rest of their forms. I'm trying to reserve most of tomorrow, late morning, for a good review. We'll take lunch about 12:30 to 1:30 again. I need you guys back at 1:30 because we got to do a check-in. I got to spend a little one-on-one time with each of you. So that's where I'll see your blank CDs and that kind of thing. I'll talk about the process tomorrow. But since you guys get 3 hours, we need to be able to start our exam right at 2. So that gives you 2, 3. That's not right. Yeah, that. Look at me counting on my fingers. This is where I am on a Saturday afternoon. So 3 o'clock, 4 o'clock, 5 o'clock is 3 hours. I got it. So we need to be able to start by 2. So kind of the same, you know, class till 12:30, take an hour lunch break, check in, and then start exam by 2. Okay. So most of tomorrow, I know it's like mush right now, you know. So most of tomorrow will be a review, but we do have a little bit more material just to get through. Some of this stuff in chapter 11 is also going to serve as a nice review. You'll see as well, things that we touched on last week. One thing we haven't talked specifically about yet is discussing submitting offers to sellers. We're going to talk about multiple offers, which is very, very real in this world that we're in right now. So it's a relative discussion. And then some offer modifications and counter offers. So as a nice review, to create a valid real estate contract, first off, there has to be an offer made. The offer has to be considered, and it eventually has to be accepted. And upon acceptance, there's that magic moment in time. We have to have these 2 things. We have to have written acceptance. We have to have signatures. And then we have to have communication of acceptance. I personally think the line helps us see that the offer is made. Buyer as the offeror, seller as the offeree. Draw the line. Again, you'll have scratch paper tomorrow, so draw the line. Buyer makes an offer. Buyer is the offeror, the giver of the offer. Makes the offer to the seller, who's the offeree, the receivee of the offer. What are the seller's 3 choices? As the offeree, what are their 3 choices? Do it with me. Accept it, reject it, or counter it. If they accept it, they're agreeing to all the terms exactly as they are. There are no changes to an acceptance. If they reject it, it's dead on the table. Both parties go about their lives as if this never happened. If the seller counters it, a counter offer is a rejection. It's a rejection with a but. I'm good with all these terms, but this, and this. When the seller counters it, the roles reverse. The seller becomes the offeror, making an offer to the buyer who's the offeree. In this scenario, what are the buyer's 3 choices? The buyer can accept it, reject it, or counter it. Anytime anybody's presented with an offer, they always get 3 choices. Let's throw agents in the mix, because let's face it, agents are in the mix. If the buyer accepts, we need to verify that it's been signed, right? My guys accept, that's nice, but has it been signed? So if the buyer accepts, we verify that it's been signed. Buyer calls their agent and says, I've accepted. Are we under contract? Buyer calls their agent. Nope, we're a step closer, aren't we? But we're still not quite there. Whoops. Buyer's agent calls listing agent. Thumbs up. Now are we under contract? Yes. because communication of acceptance has crossed the line. I highly suggest you guys drawing the line tomorrow, because you need to see that the last offeree accepts it. And then you need to see communication of acceptance going over here. So buyer's agent calls listing agent. Before listing agent celebrates, what should they do? Yeah, they should call their seller. Say, hey, guess what? We're under contract. Now you can sell it. Call your seller, then celebrate. Fair enough. Don't celebrate, because then you won't be able, hey, then you won't be able to call your seller. So call seller first and then celebrate. Any questions on this? This is our effective date defined in our contract. This is basic contract formation. Maybe you're talking about real estate, maybe you're not. For your first year law students, this is how a contract is formed. We are not first year law students though, so. And remember what we said to you guys. Let's say the problem tells you that I email and then I follow up with a text. I first emailed and then I text. Which form of communication put us under contract?
Email.
It was the email. It's the first form of communication. The text is just me following up to my email. So when your test says I called you and then I text you and then I emailed you, the call is what put us under contract. All we need is that communication to cross the line once. Questions on this? So the offeror is the person making the offer. The offeree is the person receiving the offer. Y'all, please don't get it stuck in your head that the buyer is the offeror and the seller is the offeree. 9.5 times out of 10, that's how it starts. But if you get that in your mind, you're messing yourselves up for counter offers. There are situations where the seller makes the offer to the buyer. So y'all, please don't look at offeror and go, oh, that's the buyer. The offeror is the person making the offer. The offeree is the person receiving the offer. And I just like to point out on page 358 of your book, I like bullets, simplifies life for me. So on 358, there's a nice little bulleted key points about the offer. Just make yourself a little tick to notice that. And as we said, with a counter offer, the roles change. The offeror becomes the offeree becomes the offeror. The offeror is free to revoke their offer at any time prior to acceptance. The offeror is free to revoke their offer at any time prior to acceptance, even if they put an expiration date on it. The offeror can always revoke their offer prior to acceptance. This tends to be a problem topic. Let's say I'm presenting an offer today and I'm putting an expiration date on it of 9 a.m. Monday morning. I present my offer. I say this offer is good until 9 a.m. Monday morning. I wake up tomorrow morning and go, no, I don't want this house. Can I revoke my offer? Can I take it back? Absolutely. Why? Because the offeror is free to revoke their offer at any time prior to acceptance. In order to have acceptance, an offer has to be accepted, and that accepted has to be communicated. This is our 2 steps. The offer is accepted. Acceptance has to be computed. I think it was Robert that said it earlier. The person making the offer, don't they have a right to know that their offer's been accepted? Absolutely. That's why it's not a done deal until they're notified, hey, your offer was accepted. Guys, please remember, with a rejected offer and with a counter offer, there's no going back. Once it's been rejected or countered, it's dead. You can present a brand new offer with the exact same terms, but you can't go back. Some acceptance key points, 359 to 360. Again, I like bullet points. I like it when they simplify things for me. Thank you. We need to be prompt when we're communicating acceptance. I get it, we're busy. Every single one of us are busy, and I get that. But when you're in the throes of negotiations, if you can't handle it, you need to ask for help. I don't know about you guys, but let's imagine a scenario. I'm the buyer's agent. We make an offer. Let me think about this. Can I draw my picture? See, I need a picture. So I'm the buyer's agent. So there's an agent, a buyer, offeror, and then over here you have the agent, the seller as the offeree. So the buyer makes the offer to the seller. The seller accepts it for simplicity. The seller accepts it, which means they've signed. We're verifying that. So they've accepted, we're verifying that they've signed. I'm changing my role. The seller calls me, I'm the listing agent. The seller calls me and says, we've accepted. And I say, oh, that's wonderful. Well, I'm really busy this afternoon and I got some showings and I got an appointment. So when I get home later this evening, I'll let the other side know that we've accepted. I see some of you already shaking your heads. What can happen between now and later this evening? Another offer could come swooping in, couldn't it? A better offer could come swooping in. Are we under contract? The seller signed it, but I just didn't get around to calling anybody yet. I don't know about you guys. I couldn't sleep well that night if that happened, because me knowing that my lack of communication caused the buyer to lose their dream house, probably, that'd be a tough pill to swallow for me. So no matter how busy we get, we still got to remember the basics. Remember, basic contract formation says I need 2 pieces. It takes 3 seconds to send a text, right? Come on, send the text, have the communication. I'll email it to you when I get home, but you got to communicate acceptance. I hate to say it, but I think this is where some brokers out there right now fail, is poor communication. And I think we need to work on that as a whole, all of us. I think I mentioned this last weekend. It's very true. There's an old saying in this industry that it says, if you want to sell a house, just go on vacation. That's all you got to do. Go to the beach. You'll sell houses like crazy. It's unbelievable how they just know. The universe just knows that you're trying to get away for 2 days. If you really want a vacation, you need to have somebody covering for you while you're gone. If you get sick, if you're busy because your family member's getting married this weekend, and you're going to be tied up with that all weekend, it's okay, guys. We're allowed to have a life. This is one of these industries that if we allowed it, it could suck us up 24/7. But it's okay to have a life. It's all right. I mean, the president of the United States of America is allowed to take a vacation. Real estate agents should be as well, right? So have your life, but just have your business covered when you're gone. Have a peer, have your BIC, have a teammate, have somebody cover for you. I'm on a team, And a big reason I'm on a team is because I want to teach too. And part of what that means for me being on a team, if I'm busy teaching and this is going on, I know somebody can cover for me. I remember one time I was on my way to Winston, we were still in person, and I was on my way to Winston to teach a weekend post-licensing class. On my way at 8 o'clock in the morning, I got an offer on my listing. And I said, well, yeah, I said, dang it, I'm getting ready to teach from 9 to 5. I get what, an hour lunch break and a couple 10 minutes. I can't effectively negotiate, right? Like I can't work. So I called my team leader. I said, happy Saturday morning. I need your help. She said, I got it. Don't worry about it. When I got done teaching at 5, we were under contract. I said, well, that's how you do it right there. Just turn it over, let somebody else handle it. But for me, because I choose to wear 2 hats, you guys know what I'm saying? So if you overfill your plate, if you overbook yourself, you got to have a backup. And for me, it's totally worth being on the team so I can still do this. I want my cake and I want to eat it too. And this allows me to do that. Do I have any questions on communicate? It's so important that we communicate. So when we're submitting offers to sellers, this is either the listing agent working with their seller. This is the buyer's agent submitting an offer to a FSBO, for sale by owner. Okay, and there's some rules in place when submitting offers to a seller. The law of agency says we have a duty to present all offers to the seller as soon as possible. And at that time, when we're presenting the offer, we have to disclose all information that we may have that affect the seller's decision. Do you know something about the buyer? Do you know something about their price, term, or motive? Any information you have about the buyer that could affect the seller's decision, we have to disclose at that time. So the law of agency says we deliver all offers to sellers as soon as possible. The Real Estate Commission says we have to deliver all offers immediately, but in no event later than how many days from the date of executed paperwork? Who remembers how many days? Immediately, but in no event later than, that's right, 3 days. So the law of agency says, both of them say we deliver all offers. What offer do we deliver? All of them, every single one of them. Law of agency says we have a duty to do it as soon as possible. The Real Estate Commission says do it immediately. I almost want to put that in parentheses, but in no event later than 3 days. What do you guys take from that? You're going to drag your feet when it comes to presenting an offer to a seller? No, get it to them as soon as you can, immediately or as soon as possible. When you deliver the offer, if we know of any other possible offers coming, maybe you had a showing this afternoon and their showing feedback said buyer's really interested, going home right now to write it up. We don't have to wait on that other offer, but I got to notify my seller that somebody's writing an offer up. Maybe they want to wait, maybe they don't. The seller is free to accept any offer at any time that they wish. Y'all write that down. The seller is free to accept any offer at any time. So if I know 5 are coming, do we have to wait for those 5? If the seller has the dream offer in their hand, now if they got one in their hand that they're kind of like, meh, maybe we want to wait for the other 5 to see what we're getting ready to get, but we don't have to. If the seller's happy with what they got, they're free to accept any offer at any time. Any questions or concerns about your commission and how much you're going to be paid? These need to be worked out before you present the offer. Either the buyer's agent presenting it to the listing agent or the listing agent presenting it to the seller. You already have agency agreements to spell out your commission. I think a good example of this, if you're showing property outside of your MLS, I think I got one of you in Charlotte or Concord. Is that right? I think a couple, maybe one or two of you. But there you go. But most of us are in the triad. So as long as you're showing property in the triad MLS, they've offered me compensation. If you choose to go outside of your MLS, you don't have an offering of compensation. That offer of compensation is only good for your MLS. So if I want to go to Charlotte and show a property, before I go, I need to be on the phone with the listing agent to see if they'd be willing to pay me. And if they say no, that's why we have a buyer's agency agreement. Remember, the buyer's agency agreement says I'll always ask the seller to pay my commission first. If they can't or won't, the buyer has to. So work out any concerns about commission before you present, ideally before you write it or show it, but definitely before you present. And then the last thing we're saying today, I don't have the authority, I don't have the power to bind anybody. My seller says, oh, just accept something on my behalf. I'm sorry, seller, I cannot do that. I don't have that kind of power. I present the facts, they make the decision. That's correct, Dawn. I have to join the Charlotte MLS. Yep. I have no authority. Even if they say it's okay, the real estate commission says that it's not. Questions? I think I'm done talking for today. That'll make my husband happy. So we're gonna leave off here today. Like I said, we'll get finished up tomorrow. I'm so good with our time right now. So we got a little bit more to talk about, a few more forms to talk about in the morning. We're gonna do a good review. If you have any closing disclosure problems, why don't you email me tonight so we can get that worked out. I probably won't have time to do another one of those tomorrow. So if you have any CD questions, email me tonight. We'll get those worked out. We'll finish up tomorrow morning, test tomorrow night. And you guys can check, or tomorrow afternoon, sorry, afternoon. And then you guys can check 302 off your list. How's that sound? Cool.
And we get the results on spot, right, Julie?
Oh yeah, you hit submit and it says boom, pass or fail. But yours is gonna say pass. Because we're gonna review. I got you. Don't y'all worry. Okay. All right, everybody have a good night. Sleep
Thanks, Julie.
fast. I'll see you guys at 9 o'clock tomorrow morning.
Thanks, Julie.
Thank
Thank
you.
you.